Good morning,
Good
Your Honors.
morning.
May it please the court, Brennan Wingirter with the Public Defender's Appellate Division here for the appellant, Mr. Ambreia, Washington. And if I may reserve 4 minutes for rebuttal, please. Your Honors, this case involves two of the most basic requirements of a fair criminal trial. Number one, the state's duty to preserve evidence that is potentially exculpatory for the defense. And number two, the state's duty to disclose evidence that it intends to use against the defendant at trial. In this case, the state's loss of potentially exculpatory evidence in a body camera footage video, and its belated disclosure of crime scene photographs require reversal of the trial court's judgments. These are these two issues, the loss of the body camera footage and the discovery violation, I think are easier to talk about together. And I think the timing is very important with these. So first, before trial, there was a superseding indictment issued, and that was, at least as of March 2022, the superseding indictment had been issued, and Mr. Washington had filed his discovery motion under Rule 16. In April of 2022, Mr. Washington moved to dismiss the indictment based on the loss of the body camera footage. There was a, I'm going to probably colloquially refer to it as a Ferguson motion or the Ferguson hearing, but it's a Ferguson-Merriman issue. That hearing was held on May 9th of 2022. At the Ferguson hearing on May 9th, the arresting officer testified that he had lost his body cam footage. But he said he had taken a recording of a portion of that body camera footage on his cell phone at some point. During that hearing, the trial court declined to dismiss the indictment based on the loss of the body cam footage, but did agree to give the jury an instruction at trial that it could presume that the lost footage would have favored Mr. Washington's narrative. That was May 9th. May 12th, unbeknownst to Mr. Washington, the state uploads that cell phone video clip of the body cam footage and 8 crime scene photographs into the online discovery portal that they use in this particular district.
Where did the crime scene photographs come from?
So the best that we can tell, they were in the possession of the local police department from the beginning.
So they were true crime scene. They weren't, I guess, screenshots from the body cam.
Correct. There was the cell phone. I think he was playing his body cam and recorded it on his cell phone, but then the crime scene photographs are separate. They are actual photographs that were not discussed at that May 9th hearing. There's some indication that maybe they were mentioned at the preliminary hearing much earlier on before the superseding, probably before Mr. Washington even had this attorney. But at the May 9th hearing, the cell phone video comes up, but the photographs do not. Then after the trial court has ruled that it is going to give this jury instruction, then 4 days later, the state uploads the cell phone clip and the crime scene photographs. Mr. Washington's attorney does not see those photographs until the morning of trial.
Okay, this is my first time dealing with this type of system for discovery. So can you kind of tell us a little bit about how that works? Because I don't know if the onus is on defense counsel to just keep checking.
And I can tell you what was in the record about how this particular program works. I know that there are different programs across the state that different DA's offices use and PD's offices, but this particular one in the record, the state said, well, when we uploaded it, the system is supposed to send an email to defense counsel. Defense counsel on the record said, I didn't get that email. Sometimes I get those emails from the system, sometimes I don't. It's not clear to me from the record if defense counsel just checked the morning of just to be safe, but he told the trial court, I did not know that these had been uploaded to the portal. I did not get a notification of that. And obviously no one separately told him either. So if we're depending on the electronic email, counsel testified, but told the trial court he did not get that. I think that system is supposed to send an email. That may or may not always happen from this record. That is what was established. So defense counsel sees those photographs for the first time the morning of trial, moves for continuance, moves for a mistrial. The trial court kind of goes through the same question Your Honor just asked about how does this work? How do you get notice? Did you get notice? And then the trial court says, well, I mean, they were there. 6 days ago, you could have gone into the discovery portal, you could have looked at them. So I'm not granting a continuance. I'll give you some time to look at them, and then we're going forward with trial. Now, our position is particularly under the cumulative error argument, though you can look at these individually, but collectively, I think it's important to look at the timeline of these events and when these photographs came in. Because when the trial court ruled on May 9th on the Ferguson motion about the lost body camera footage, the photos aren't uploaded yet. They aren't discussed at the hearing. They're not in the discovery portal at that time. It's 4 days later that those crime scene photographs get uploaded. And then it's another couple of days before trial that defense counsel actually sees them. So when the trial court ruled on the Ferguson motion, it did not know that those crime scene photographs existed. And actually at that time, it did not know if the state was going to use the cell phone clip at trial either.
Why is that?
The trial court specifically asked the ADA at the time, do you plan to use that video clip at trial? And the prosecutor said, well, it's kind of hard to say. It sort of depends on how the court rules on this motion.
As to the photographs?
As to the video clip of the portion of the body camera footage. The photographs were not discussed at that time at all, at that hearing. So trial court rules, I'll give the jury instruction that the jury can presume that the missing body cam footage is favorable to the defense. So at that point, the state has the officer who's going to testify. They have the handgun that they physically recovered, and the defense has this jury instruction. By the time we get to trial, the state has the officer who's going to testify, the gun, the video clip of a portion of the body cam, and 8 crime scene photographs. And counsel, in moving to either continue or for mistrial based on the late discovery disclosure by the state, explained to the trial court, look, our defense theory was going to be, we're attacking the credibility of this officer. He lost his body cam footage and he doesn't have any crime scene photographs. And so who knows what really happened at the initial encounter with my client. Well, on the morning of trial, that strategy goes out the window because we now have 8 crime scene photographs that corroborate the officer's narrative. And so that to me, that is why they are so connected, is because that ruling on the Ferguson motion at that time, perhaps the significance of the body camera footage was a little bit lower.
So the pictures, were they introduced?
Yes, Your Honor. So they did, the trial court ruled that they could all come in.
Well, let's say the trial court had said, no, they can't come in. I mean, as opposed to ordering,
Correct.
They can't come in.
Yes.
There was no ask for a continuance, I assume, or was there as a result?
Counsel did ask for a continuance, yes, Your Honor.
But if they had not come in, I mean, you still wouldn't have been able to use the defense that the officer didn't investigate and take pictures because you can't, I mean, because you know there were pictures made, right?
At that point, yes, I suppose, but that would be unethical, I think.
Yeah,
I would think at that point for counsel to argue.
That's right, so you can't make that argument. So whether they disclose it the morning of or they disclose it 2 weeks earlier, you've lost out on the argument.
Well, I think you have
At least, I mean, you can still talk about the video being disappeared,
right,
but with regard to the crime scene photos, you can't argue that.
exactly. And that was exactly Mr. Washington's argument for why this was so prejudicial. So you have whether the photographs come in or not, the fact that the defense had prepared for trial thinking they did not exist, that they were not there, that was not a thing. And then the morning of trial, it turns out that they are.
So speak to the trial court. The remedy is rarely going to be a dismissal of the charge for a late discovery or disclosure of evidence. They gave defense counsel the opportunity to review the evidence
Yes.
or the photographs. Defense counsel knew, somewhat piggybacking on what Judge Montgomery said, knew the officer was going to testify that the gun was in plain view, right? So, you know, in a sense, defense counsel had to be ready for that approach. Now, granted, defense counsel didn't know there were photographs, you know, to memorialize the officer's testimony, but he knew that this testimony was coming. So speak to the fact that, you know, the trial court did give defense counsel the opportunity to kind of adjust to the fact that these photos were there and were going to most likely come in.
Sure, I think the point there is that that opportunity to view the photos the morning of trial is just too late. And here, when we're talking about what is a remedy for a state's discovery violation, there is no penalty at all here. I mean, the state did not, I don't think the state has even tried to defend that this wasn't a discovery violation. So we have a discovery violation, it's belated disclosure 6 days before trial.
So
No,
is the violation based on the judge's instruction that you've got to provide discovery so many days before trial?
yes, Your Honor.
There's no rule or statutory prohibition about showing it up on the day of trial.
Correct. All of the case law is sort of takes it case by case basis. I mean, the typical.
You said it's a discovery violation, so I'm just trying to make sure that it was perhaps the judge's rule or court's rule that you have to do discovery by a particular day.
I think it's actually two things. So Rule 16 requires a continuing duty to disclose. The prosecutor essentially admitted, well, the officers have had these crime scene photographs the whole time, and there's case law that if the officers have it, the state has it. So when they were aware of the photographs is when they should have been turned over.
Is there any agreement on this, this system, this electronic discovery system? Is there anything that we can see in the record that required, or was there an agreement between the state and defense counsel about how that was supposed to be used? I mean,
So, because
I don't
kind
understand.
of going along that, I mean, you keep saying, and I understand why, they weren't disclosed until the day of trial. Well, that's not 100% accurate. I mean, the state's going to argue, well, no, they were disclosed 6 days before trial.
That's correct. That's correct.
And so what's the difference in this case and then a DA's office saying, hey, open file discovery, come by my office anytime, and you decide to wait till the day before trial to go look through 3 bankers' boxes of information and realize, oh, something's in here that now is going to blow my defense out of the water. I need a continuance. And I think in one sense, that's kind of what Judge McMullen is asking is there an agreement that not only will I upload this when I get it, just assuming, when I got it, I uploaded it. Do I also need to notify you, or is it okay that we all rely on the system? And if it's okay that we all rely on the system, how is that any different than my hypothetical of, hey, open file discovery, come by my office anytime, and you wait till the last minute to check the system?
I completely agree. And if I said that it was not disclosed until trial, I misspoke. It was definitely disclosed 6
Discovered,
days.
discovered by defense
Learned by
counsel.
defense
Yeah, no,
counsel,
I
fair.
knew what you mean. I don't think you were meaning anything improper by that.
So I think the issue there, though, is whether they're disclosed 6 days before trial or the morning of trial, discovered, or let's say it's counsel's fault for not looking until the morning of. I think from the record, both offices just sort of assume they get an email notification, that's it. That was the extent of the discussion. But what is different in this case, or why it matters in this case, is how it is tied to the denial of the Ferguson motion. So again, on May 9th, when counsel moves to dismiss for the loss of the body cam, not knowing that the photographs exist, the trial court doesn't know that the photographs exist, we have a little bit more of a level playing field on the remedy for the Ferguson issue by giving the jury instruction rather than dismissal. If the photographs had been timely disclosed, at that point on May 9th, perhaps that changes the trial judge's ruling on the Ferguson motion, because now that the state has these photographs, in our view, that makes the body camera footage even more significant to the defense because it's lost. So then the jury instruction doesn't become a good enough remedy at that point. That's one option. Another option is maybe Mr. Washington enters a plea earlier on, right? So all the what-ifs that surround how might that May 9th hearing have gone, or how might the trial preparation have gone differently if the photographs had been timely disclosed, all those what-ifs are what Rule 16 is designed to prevent. And so I understand to some degree this is on counsel for not looking until the morning of. I acknowledge that. But our position is it's not even the day, the 6 days, it's before the Ferguson motion. It's when the state became aware of the photographs, why weren't they disclosed earlier, then maybe that affects the outcome of the Ferguson hearing.
And I agree with you. I mean, the case law of the state is the state, so to speak. But at some level, there also has to be a practicality to that statement. And so when you say the prosecutor testified or stated to the court that, oh, the police have had these all along, like, did the prosecutor know they had them all along, or did the prosecutor find out on day 6, hey, by the way, we forgot to give these to you, and therefore the prosecutor uploaded them. Because I do think that makes a difference. I mean, I'm not disagreeing with you that if the police have it, technically the state has it.
Right.
But if the prosecutor doesn't know they have it, he can upload it.
Agreed, and I think that goes to the level of intent, which is factored into the analysis. What is the appropriate remedy for a discovery violation by the state? Was it intentional, was it not? Our position here is that there has to be some penalty, whether it's intentional or not, or some remedy for this discovery violation. And our position is not granting the continuance, going to trial that day, not excluding the photograph. At the very least, the trial court could have excluded the photographs. I recognize that may still have, we may still have the same argument on how do we attack that credibility. But then that goes to, should the continuance have been granted? So there's a lot, I think all of that plays together, and that's where we get to the prejudice, which is what we emphasize in the cumulative error section of the brief, about how that Ferguson issue and the discovery issue are tied together. Both remedies by the trial court being inadequate, and together affecting the ability of Mr. Washington to get a fair trial, which is ultimately what we're concerned about here. And we would ask the court to reverse. Thank you.
May it please the court, Catherine Redding on behalf of the state. I'll just quickly touch on the Ferguson, just because counsel has brought that up. The defendant is only arguing about the consequence of what the court considered to be a Ferguson violation. The court decided that the appropriate way to protect the defendant's rights in this particular case was by giving the missing jury instruction, and the defendant believes that the case should have been dismissed. But here, there is nothing in the record that suggests egregious police misconduct that would justify dismissal. Officer Keller testified that he activated his body camera, that he had it on, it recorded his interaction with the defendant, that he attempted to preserve it by following his department's guidelines, he uploaded it onto the system, and that at some point after that time, after he uploaded it, it became lost. He said he didn't know what happened to it, he denied intentionally, and was questioned about this, whether he had intentionally destroyed the video, and he denied under oath doing something in an attempt to destroy or lose the video. The second part is that this video, the evidentiary value was relatively minor. The state had elected to prosecute the defendant for evading arrest, unlawful possession of a firearm by a convicted felon, and driving on a suspended license. So the footage theoretically could have contradicted Officer Keller's testimony about the initial interaction with the defendant, but the state was able to rely on evidence in addition to his testimony to prove these three charges. For the evading arrest, it had the surviving video clip. And what the record will show is that Officer Keller, because he had to tase the defendant when he ran away, he recorded the portion of the body camera footage that showed the tasing and the evading so that he would have it, because there was likely to be a separate use of force kind of inquiry, so he wanted to have that readily available. So we have that clip that shows the defendant running, that shows the officer tasing him.
What bothers me about this case is I don't understand why the trial court, once both parties realized the photos were in, or the photos were uploaded, what would have been the problem with giving another week for everyone to prepare? Because clearly, defense counsel didn't realize the photos were there. So what would have been the problem with that?
I think the issue is that the state is not conceding that there is a discovery violation.
I get that, I get that. And I don't understand why, I mean, to Judge Dyer's point, this is, this system, nobody tells us anything about how the system is supposed to be utilized. It's effectively what we're looking at it as an open file discovery. So I don't really understand what the argument is about mostly, but the trial court here could have easily said, I'll give you a day, I'll give you 2 days, I'll give you a week, because you're operating with truly new evidence here. The state didn't give you this evidence, or you say the state didn't give you this evidence. The state, I don't know if they conceded at trial. I don't remember whether they conceded the day of that, it was in the system or when it came up, but to remedy this problem, why wasn't there more time given?
think because if you look at the record, and the record does not have very much in it about when the request for discovery was made or what the kind of agreement was on how discovery would be produced. But if you look at the record and the trial court's findings, it said, the photos are in the record for this court to review. It said, look, these photos show exactly what we've talked about at pretrial hearings. They were referenced in the incident report, and they were discussed at the preliminary hearing. So you can't be surprised by their existence, even if it's the first time you're seeing them is the morning of trial. There are several issues. One, you knew about it from the time of the preliminary hearing. Two, you knew about it from the time you got the incident report, that they existed. Three, they were uploaded 6 days before trial, and it's not the state's problem or that you, defense counsel, waited until the morning of trial to check the system. So whether there was an email or not, there was an issue of the state uploaded them 6 days before trial, plenty of time to kind of.
Let me get a clarification on
Sure.
what you just made. So you're saying that at the preliminary hearing and other pretrial, that there was a discussion that photographs were taken?
That is what the trial court found. We obviously don't have a transcript of the.
Right, but that's the trial court saying, look, as you read the ruling, the trial court saying, look, pictures, the fact that photographs were taken, there are crime scene photos were taken, you knew about that. Well, you may not have seen them, you knew they existed.
Yes.
And then he added, and they were uploaded 6 days prior to trial.
Yes.
And so the fact that you waited till the last minute is not reason for granting a delay.
Yes.
So it goes back to, I guess, my hypothetical. Here's open file discovery, and oh, by the way, we took crime scene photos. You wait till the last minute to go look in my box at the office to see them. I'm not giving you relief.
What are we talking about with the preliminary hearing? Is that actually in the record that defense counsel knew that there were photographs, crime scene photographs?
We don't have a transcript of the preliminary hearing. The trial court, when it makes its ruling about these photos, makes reference to the preliminary hearing. At least that's in the record, the trial court's statements, and that is what I believe the court to have said.
Okay.
Let me ask you a question too, because I've not had a chance to review the evidence and the pictures, but how would you characterize, I mean, this is not firearm possession and driving on a suspended license typically, the driving on suspended doesn't involve pictures. Resisting arrest, we have the person running. So, is there a picture of the gun?
There is a photograph of the gun, and it shows the gun on the passenger seat of the vehicle.
Which everybody knows that's where it was all along. Based on previous testimony.
That is consistent with Officer Keller's testimony.
Okay, and then is there any other picture that has anything to do with the offense? Of those eight, other than a picture of the gun on the seat that you're aware of? And I'm not-
I don't believe so. So the photos are in the record. There's a few, and I think that starts, picture of the vehicle with its tire in the yard, and then the next photo is of the driver's seat, and you can see the gun, and then there's a up close photo of the gun, and then there's a photo of the officer holding the gun to
I think the
demonstrate.
issue
whatever he
was
wants
whether the gun was moved or whether it was in fact, in plain sight.
Correct.
At the time the officer went to do his alleged community caretaking function.
Right. And the photographs of the gun are not going to
To show
there's
that.
not,
Yeah.
the video is going to show, the missing video body camera footage is what would have shown where the gun was to start with. The photo of the gun sitting on the passenger seat is consistent with Officer Keller's testimony, but does not preclude the defendant from presenting the defense that he presented, which was attacking Officer Keller's credibility and suggesting Officer Keller planted the gun there.
Yeah.
So, the photos don't contradict that theory, but they also don't contradict the state's theory. So we have, to the extent.
So you're basically saying there's really not prejudice here?
There is not. And there certainly is not actual prejudice because the state uploaded them. The defendant's the one who didn't notice that they were there. If there is an issue, which it seems to suggest the record does, that maybe he doesn't get the emails consistently. That seems like, well, maybe if you don't get the emails consistently, you have an inclination that you should check before the morning of trial.
Or maybe double check your spam filter.
That there's an inclination that there is an issue with the email system. And so it would behoove defense counsel to check before the morning of trial. And in fact, you can tell from the record that when the defense attorney contacted the court, said we have to have a hearing, the video has shown up, he hadn't even looked at it before the hearing started. So the trial court did not continue the trial, but did look at the photographs, make its ruling on the photographs, and then offer defense counsel opportunity to look at these photos before trial actually commenced. And you can't say you're unduly surprised by these photos when the record, at least the trial court's findings, is that they were maybe not seen before trial, but the counsel should have been aware given the prior proceedings. And for these reasons, the defendant is not entitled to relief on his discovery issue.
Okay, can you speak to I think you said that the cumulative argument, their cumulative argument issue was waived. Is that what you argued in your brief? Or am I confusing that with another waiver argument in a different case that you all made?
I do not believe that I argued waiver in this one.
Another case.
The state's position is,
I'll ask it then.
If that's your argument, be prepared.
I do not believe that cumulative error was waived in this particular case. At least I have not argued
Good
it, but
answer.
obviously the court can find waiver should it believe that's appropriate.
This is the first, this won't be the first time that human error will come up.
It's on the docket
Yes.
quite a bit today,
Yes.
so.
But in this case, the defendant has not shown multiple errors that can accumulate to cause cumulative error such that he is entitled to relief under that particular doctrine. So unless this court has any further questions, the state asks you to affirm the judgment of the trial court. Thank you.
Thank you so much. You have your full 4-minute rebuttal.
Thank you, Your Honor.
Let me ask you a question before you get started.
Sure.
How does the gun preclude, the picture of the gun precludes you from making the argument that the gun wasn't really in plain view? You still got your Ferguson instruction that the only way you really would have known is in plain view is the body cam, and they lost it. I mean, so how does that really change your argument?
I think that's exactly the point of our argument. And I probably didn't do a good enough job the first time around, but just now in the discussion, there are 2 points that I think illustrate exactly where the prejudice is. The state agrees the missing video is the only thing that would have shown if the gun had been moved, which was the defense theory about whether it was in plain view or not when the officer approached. So the missing video is the only thing that could show that. That's what we don't have. The photographs are consistent with Officer Keller's testimony. That's what we're trying to attack on credibility grounds. And so if you go back to May 9th, when there are no photographs discussed, then the trial court's decision that jury instruction as a remedy for the lost body cam footage is appropriate. I think at that time it's appropriate. It's when we later learn about the photographs and the photographs come into play that the significance, the second prong of the Ferguson analysis, the significance of the body cam footage then skyrockets, because that's now the only thing that we could have to discredit the officer's testimony, and we don't have it. So on May 9th, when it's just the video and the officer's testimony, fair enough, you get a jury instruction. But once these photographs are coming in, that's bolstering his credibility, which is exactly what we would be attacking with the lost body cam footage. Now that body cam footage becomes so much more important because it's the only thing that would support potentially the defense theory, and we don't have it.
What about the state's comment that the trial court mentioned that your client was aware of that the pictures existed? May not have seen them, but was aware as far back as the preliminary hearing.
Yeah, I think I have to agree with the state. The trial court said that. I don't think we know that for sure. I mean, I can tell you there's no guarantee that this attorney was that attorney at the prelim. Whether Mr. Washington himself knew, are we putting the burden on him? That I think is just too unclear for the record, though the trial court did say,
Well, I
hey,
guess-
these have been around.
So, then I'll be quiet. But if the trial court said it, and we have nothing look at to contradict what the trial court said, don't we have to accept it?
If you accept it based on the trial court's statement alone, without a transcript of the preliminary hearing, I think the question still becomes, what did the trial court know on May 9th when it ruled on the Ferguson motion? Let's say the photographs existed. They weren't introduced at that hearing. The state made no indication of using those photographs. Even if they did exist, the state doesn't have to disclose them unless they intend to use them in their case in chief under Rule 16. What if the state waited to get, I'm not saying they did, but what if the state waited to get the ruling on the Ferguson motion and then they're like, oh, we better use those photographs now. Now we'll turn them over. That's the problem with the delayed disclosure and the timing with the Ferguson motion. That's why the lost video becomes so much more important, and that's why the delayed discovery goes to what did the defense have that it is anticipating what the state is going to use against them at trial. They could have all kinds of evidence. They don't have to disclose it unless they're going to use it. Disclosing it that late in the game after the trial court has made a ruling on the lost video footage, in our view, is just simply unacceptable in terms of how a fair trial is supposed to play out.
Did the evidence seem to reflect that a particular officer in the case was the one that took the picture?
I don't believe so, Your Honor, and
Somebody else did?
I'm not 100% sure about that in the record, and I apologize.
Of course, another thought is, for the defense, would be to say, well, the officer had the pictures posed to reflect that it was there and then threw away that video.
So to be fair, Your Honor, I think,
So the pictures come in to help you with the photo.
and to be fair, I think that was the tack that defense counsel tried to take, and that was the basis of the prosecutorial misconduct action or claim when the prosecutor called that offensive for him to argue.
So if a second person took the pictures, it makes it harder.
Hardly.
If I could make one
That means
final,
you have two people involved.
Judge Montgomery?
I'm sorry,
No,
no problem, Your Honor. I just wanted to very quickly answer, the state argued that the discovery issue was waived, not the cumulative error in this case. There was a waiver on discovery that we responded to in the reply brief. We'd ask the court to reverse. Thank you, Your Honors.
Thank you. All right, we'll take the matter under advisement. Madam Clerk, you may call the next case.